Right, good morning, everybody. Yeah, so I'm Adam. I'm from Withers and Rogers, and I'm going to be talking to you a little bit about what we do in the world of intellectual property. But before I do, I thought it might be useful just to have a bit of a brief whistle-stop tour through IP, then some benefits of protecting IP, why you'd want to, and the key considerations, and then I'll talk about what we specifically do at Withers and Rogers and what we offer. So a question we often get asked is, what is IP? Well, in a nutshell, it's basically a creation of the mind. So it covers things like inventions, literary and artistic works, designs, symbols, names, and any images used in commerce. And there's different types of rights, IP rights, that are available to protect the different types of IP. In summary, these are patents, which is what I do, and they protect the way a product works. We have designs that protect the way a product looks. Trademarks, which I'm sure everybody's probably fairly familiar with, which protect a manufacturer or service provider's reputation and their brand. Copyright protects things like literary and artistic and creative works. Also things like software code is protected with copyright. And then trade secrets, which are used to protect secret business knowledge that perhaps can't be patented, or due to various considerations, you might not want to patent it and instead keep that information secret to the business. And there's various ways to do that. So these rights kind of knit together to sort of form a smorgasbord of IP rights. So you see down there, we've got trademarks, we've got some well-known brands. There'll be trademarks in place to protect not only the name of the brands, but also the stylization of the logos. Designs, so up there we've got a kid's trunky suitcase, which was the subject of some fairly famous sort of design legislation in the UK a few years ago. Obviously, we've got patents. So you think of big companies like Dyson that have very, very heavy on their patenting activity, protect the way their products work to deter competitors. And then, as I mentioned before, we've got trade secrets. So things like, the Coca-Cola recipe, what's in WD-40, things that have been kept under the hood to protect that brand's product. May not be possible to protect these things with patents, and also by virtue of filing a patent application, that has to be published. So you'd basically have to tell the world how you did it. And obviously, Coca-Cola and the likes of WD-40 don't want to tell the world exactly what's in their products. Another example is KFC. What's in the KFC recipe? It's another famous one. So why is IP important? Well, it helps a company to protect their place in the market. It deters competition. And it also sets a barrier for market entry, because it means that your competitors have to find a way to design around your patents to try and avoid infringing your rights and potentially being taken to court. It adds value to the business. It shows investors value, which can be particularly important for the likes of startups and SMEs. And it can allow an evaluation of value for the company, particularly at exit points, again, for investment purposes or for purchase or sale of the company. Another important consideration is tax relief incentives. So we've got things like R&D tax credits, patent box tax relief. They're things that I think other people in these meetings have spoken about in the past, but just focusing in on patent box as one example, purely because it can be quite attractive to startups and SMEs in particular. So if you have a granted patent, you can apply for patent box tax relief, and that allows a reduction in corporation tax rate down to 10% on any eligible patented products and services, and it applies to worldwide sales. It's important to appreciate that obtaining a patent isn't a particularly cheap process, but the relief that you can obtain through patent box can potentially dwarf the cost of obtaining the patent in the first place. And we do have some clients who patent box tax relief is one of the main purposes for actually filing a patent application with us. So it's an important thing to consider. So a couple of examples here. I think there's a bit of a common misconception that to get a patent granted, it has to be the next big thing in technology. And in many cases, most patents are granted for fairly incremental improvements in technology. So we've got a couple of examples here. So on the left there, we've got the original the telephone for Alexander Graham Bell way back in 1876. And there's a little bit on the bottom there on the snip that just sort of says this is kind of how patents used to be, where the inventor would just say, I've invented this, and here's my patent for it. Patents are assessed a lot more rigorously nowadays and go through a strict examination process. So it's a little bit different nowadays, but you do occasionally still get the odd sort of crazy one cropping through. So here we've got a granted patent for a cork swimming suit. Just sort of pick this up as a bit of a silly example, really, where this was basically like a swimsuit made out of little pieces of cork joined together with string. And the idea was to allow the wearer to be able to move freely but still be buoyant, and also apparently look fashionable at the same time. So you do occasionally see these slightly strange examples of patents coming through. They don't have to necessarily be the next Dyson, for example. Couple of key considerations. So in order to get a patent granted, the invention must be new and it must be inventive. And important to note there that anything that's been made available to the public up until the day that you file your patent application is fair game for the Patent Office to cite against you to try and prove that your invention is not new. So a really important point is you've got to be thinking about your IP very early in the process. And in particular, it's great if clients and prospects can come and talk to us at the very early stages, so at least then we can sit down with them and help them understand if this is something that's worth patenting before they've spoken to anybody else about the invention, because by that time the cat's out of the bag and it can be very difficult, if not impossible, to still secure them a granted patent for the invention. Right, so moving on to Withers and Rogers. We are a large European-wide firm of patent, trademark and design attorneys and dedicated support staff. We can also advise on trade secrets as well. We were originally founded all the way back in 1884 by Mr. Withers and Mr. Spooner back then, before later merging to become Withers and Rogers as we are today. We're a single firm spread across multiple jurisdictions, and we have offices in the UK, in London, Warwick, Bristol and Sheffield, and also in Paris and Munich. And this allows us to provide a really joined up service for our clients in a one firm manner. So clients can come to us, we can deal with all of their IP rights all across Europe. We really get to know the clients and we build client teams with the right competencies, and we work together collaboratively on client matters. So we work very collaboratively with our colleagues in Paris and Munich, again, to sort of provide that joined up service. In Germany in particular, that's the next slide. So yes, so our attorneys, with being a very large firm, we have the benefit that our attorneys have a wide range of backgrounds and specialisms. So chances are, there's over 70 attorneys in the firm now. So the chances are there's nothing that you can throw at us that somebody in the firm can't handle. I personally sit within the electronics, computing and physics team in our Sheffield office, and I work mainly on automotive technologies, telecoms and software-based IP. A few other bits and bobs as well, but that's predominantly the bulk of what I do. So what do we offer? Well, we can offer full coverage of European patent prosecution, including things like opposition and appeal proceedings, if things get contentious and get that far. We can also operate before the European Union Intellectual Property Office via our French and German colleagues on trademark and design prosecution. We can do prosecution of patents, utility models, which is a German thing, trademarks and designs in the UK, France, Germany, Austria, and also Norway. We have a lot of design and defense and enforcement capabilities, again, across Europe for the wide range of IP services that we offer. And sort of special point to Germany, we can offer specific legal advice and service in Germany in relation to unfair competition and copyright, licensing, and the law on employee inventions, which can get a little bit tricky. So just to sum up, really, I think one of the key messages that I'd like everybody to take away today, particularly if they're talking to anybody that talks to them or mentions about their IP, is to think about protecting it early. Ideally, talk to a patent attorney or trademark attorney as soon as possible, early in the process, so that they can make an informed decision on whether they want to take that forwards. Many benefits of protecting your IP. So again, protecting your place in the market, adding value to your business, and also those tax reliefs that incentives that we mentioned, particularly patent box. At Withers and Rogers, we're a single firm spread across multiple jurisdictions. We can handle a full European IP prosecution for a client. And yeah, we can provide a fully joined up pan-European service to our clients in a one firm manner, one-stop shop. So with that, I think I will sum up and take any questions.
Thank you for that, Adam. You did briefly touch on there around the matter of the employees of a company
Yeah.
and work or inventions they may have done that's relevant. Is that can that be a very difficult area because presumably the individual may not want to actually agree that it's the property of the employer?
Yeah, yeah, it is a bit of a tricky subject sometimes, particularly in the likes of universities where you've got, potentially PhD students or sort of summer interns and that, and the lines between who owns the IP in those situations can get a little bit blurred. For bigger companies, it will usually be stated in the contract of employment that any IP generated as part of that person's duties, normal duties, particularly if there's an expectation that they might invent. So if they work in R&D, then those rights, in most cases, automatically transfer to the company anyway. But in certain situations, like I say, particularly we see this in a lot in university scenarios, it can get a little bit tricky, and the rights may belong to the inventor rather than the employee or the university in that case. Other examples are if the person invented the product or service or whatever it may be outside of their usual working hours, then in certain situations the rights can still belong to them rather than the employer. But it's one of those where it all depends on the facts. But it is something that's worth bearing in mind because the last thing you'd want to do is file a patent application and get a patent that ultimately you don't own in the end. So it's something worth exploring in the early stages.
Thank you.
Can I just ask, Adam? I've had this
Mm.
recently with a client of mine where they applied for the patents and the trademarks in the limited company name and have decided to not proceed with the limited company and transferring it to their own name. So, as an individual, the director of the company, if you like, is that something that you come across regular, or is that quite unusual?
It it's that particular scenario is quite unusual. We do handle the transfer of patent applications and patent rights via assignment quite regularly. Often it goes the other way, so it will be in the name of an individual or potentially a small company. They might get bought out or something and gets transferred to a bigger company or an umbrella corporation or something like that. It is quite unusual to see it go the other way. Yeah, it's not something we come across very often. It's something we can help with if there's any need, and feel free to drop me a line separately, Lindsay, if you want a hand.
Lovely. Thank you.
Okay.
Adam, I think it'd be worth mentioning that in one of our other LMP groups, we have a guy called Mark Ashton. I don't know if you've come across him.
Name rings a bell.
Yeah,
Yeah.
he basically heads up a collection of business coaches who all work with different specialisms with companies abroad.
Right. Okay.
And part of the section is working in European countries.
Hmm.
So I think it'd be worth me introducing you to him
Yeah,
because
that'd be
I think
great.
your
Yeah.
your France, Germany, Austria connections will almost certainly have some synergy.
Yeah. Yeah, that'd be great. Thanks, Colin. Appreciate that.
Okay, yeah, no probs.
I know Colin's been giving you some valuable intros, but what's
Mm.
a good intro for you other than a direct client? Somebody to collaborate with, should we say?
Yeah, I mean, we get a lot of sort of direct referral work through the likes of solicitors, sometimes from accountants, sort of tax advisory services, that kind of thing. Um, a good intro for us is, basically anybody that's working in technology. Um, we work with a wide range of different clients. The ones that are, a good fun to work with, or perhaps the most fun to work with in some ways, are the likes of sort of startups and SMEs. Um, Basically, because you get in early doors, you can sort of forge that relationship with the client, and you often sort of get the privilege of being able to sort of see a bit more about what's going on behind closed doors. Potentially go around and sort of have a look at the factory and kick the tires and see exactly what they've got going on. So yeah, those sort of service providers and also SMEs and startups are perfect for us.
Adam, quick question on
Yeah,
business owners that are looking to potentially exit.
yeah,
So they've gone through, they've established a business, they've grown. They're now thinking 5 years from now, maybe is the time, but they haven't protected a whole host of things. And there's an example I've got with somebody I've been working with recently. Nothing's really been protected. They never thought about that. But actually, in terms of driving their value up, protecting a lot of their IP and other things is probably quite important and will give
yeah.
them greater value in that sale. At what point is it too late for a business to start thinking about protecting something that they haven't, if it is too late?
So for things like on the trademark side and the branding side of things, that's quite flexible. A lot of companies will wait until they've established a bit of brand reputation before they sort of proceed with trademark protection. With things like design protection, there is a grace period in the UK of 12 months for disclosures by the designer. So that gives a little bit of flexibility. I don't know whether it would be long enough in the sort of case that you mentioned, Mark. Um, Patents is more tricky. There are some countries around the world that do offer a grace period, but generally, as far as patents are concerned, once you've made the information public, it's too late. Um, but obviously, if there are other things that company have got in the pipeline, that it might be worth filing a patent application for, even if it's a very sort of narrow, targeted application where you're not trying to, get the broadest protection you possibly could, like you perhaps would in normal circumstances, to try and get something through granted more quickly, to help with the value of the business. That's something that could be considered if they do have other projects in the pipeline that are still secret at the moment.
Brilliant, thank you.
All right.
A further thought, Adam. I've recently started conversations with Leeds Beckett University Knowledge
Mm-hmm.
Share, and they're starting up some groups for entrepreneurs and developers, as
Okay.
well as for people connectors, which is where I've been invited in. But the other groups I think would be of huge interest to you in terms of the startup and development side.
Mm-hmm.
So I'll keep you posted on that.
Yeah, thanks, Colin. That'd be great. Thank you.